Come on. Hello, everyone. I saw people were here early, so I thought I would come in and give you an update. This says I'm live, but I can't really tell half the time. I think, oops. I think I want to give you an update on a motion that the defense filed requesting Sarah's actual phone. And the state has responded. So I'm going to show you that. The state is saying, no, forget it. They're saying basically, well, I'm going to read part of this to you. It says the defendants assert, oh my God, I can't speak. Okay. The defendant's assertion that her prior plethora of attorneys had no opportunity to see or review her cell phone is patently false. If they never chose to avail themselves or retained a digital forensics expert of the opportunity to inspect the phone, it was of their own volition. The digital imaging of the phone has been disclosed in discovery. The defendant can choose to attempt to enter portions of the digital imaging, like the state at trial. The state will introduce the physical device into evidence at trial. And what they're basically saying is, look, we're not going to give you the actual phone. You have everything that was on the phone. And this sounds like I could see somebody saying that the defense's request for the actual phone so they could just look through it instead of going through the whole big extraction. I could see someone saying, well, what's the problem with that? The problem with that is possible issues on appeal. So if this case goes to trial, if she's convicted, and if she then appeals it, if the phone was in the hands of the defense, nobody can say that nothing had been changed. So they have to hang on to it. And that is, I think, part of why they're saying no. And that's why it is important that they don't just hand over the phone. The other thing in here that is interesting is point 4 from the state. The state has explained to the defendant in open court that she's permitted to have an expert examine the phone at the sheriff's office under the supervision of the sheriff's office and the state attorney's office to maintain the integrity of the original evidence. And she's permitted to do so. And they said the defendant's latter wish was already agreed to by the state, and we await coordination with the defendant's latest counsel and any expert she retains. So it sounds like she didn't actually go and examine the phone at the time she was allowed to view the evidence. So that is the little update. And I'm going to switch over here. So now we are just going to chat and wait for the hearing to begin. We have about 9 minutes to talk. Well, that's a long time. I hope you all have a lot to say because I don't. Back is laughing about the prior plethora of attorneys. Yes. States getting their sass in where they can. Love it. Yeah. Yeah. Good for them, right? I might have started too early. Betty Davis, my dears, says, I'm cutting out. Am I cutting out for everybody? Uh-oh. Something wrong with the audio. Let me. I don't know if I can change this. What's happening with the audio? Audio has hiccups. Okay. Let me see if I can change some settings. Let's see. Oh. Cancel. That won't work. Okay. I'm just saying test, test, test. Is the audio still cutting out? This is bad if the stream is not working properly. Oh, Gal is saying she rewinded a minute back and there's no hiccups. That it's probably a buffering issue. I hope so. SN says he or she thinks it's my internet connection. I have the highest speed internet I can buy where I live. So I don't know. Let me see. I'm trying to see if I can change something here. To make it stream more smoothly. Sorry, guys. Okay. I just changed a setting. Hopefully that works. So for some people, the sound is fine. Oh boy. Okay. Oh, okay. Cheryl says it's better now. All right. I had to change some settings here, and I don't think there's anything more that I can do with it. I am not a tech wizard. You all know that. I'm actually really bad with it. Okay. Let's get back to Sarah Boone. So we're still waiting 3 more minutes. Kay Reese says, hey, I love your videos. Thank you. That's really nice to hear. A lot of people complain, so it's really nice when somebody says something good. I'm going to make a video with Watson for you guys. Some of you send me super stickers or super chats, and I've been saving them up because her favorite toy got broken, and I bought her a new one, and I'm going to let you watch her open it. So for the Watson fans. Oh, okay. It looks like the pool cameras are on. So we'll see how it goes. We're just right now hearing static. If the sound is too loud or too quiet once it gets going, let me know. Hello, Buffy. AKA the cat lady says might have to refresh on your end. I'm not sure if that means me, but I don't know how to refresh because there's all these settings. And all my little gadgets are telling me that I have a good connection. So I don't know. It says my connection is good. Child of God is suggesting that I reboot and turn every. Do you know how much is involved in setting all this up? It's not like I can just reboot. What do you guys think the judge is going to do? Is he going to split things down the middle and be generous with the defense? Hello, True Grit Granny. Metzger Ann asks what time the hearing begins at 1:30. So it is 1:31 right now, so it should be starting now. But, where I worked, court was never on time. So sometimes I want to start 5 minutes later to avoid just sitting here. Somebody in the chat is named We're All Mad Here. What a great name. You're welcome, Kay Rees. What's on the agenda? Sub Rosa is asking. A whole lot of motions. There's been a lot of back and forth, arguing. The big thing today, and I talked about it at the very beginning, was Sarah wants her actual phone. Someone is saying hello from Finland. Hello back. Hello from Canada. Kay Rees, I loved your analysis on Paul Ferguson. Thank you. A lot of people didn't. Colleen says hi from Connecticut. Hello, Connecticut. Marie, thank you, Marie, for your comment. So I see that Sarah is sitting there with the waist shackle on. And I think that her hands are cuffed. It's hard to tell. And we're getting this video from behind. I wish we could see her face. Does anyone know who these people are? Sitting with Sarah? Hi, Devin. Hello to the UK. We're not close enough to see if Sarah has staples in her blues. Oh. This this law and crime is freezing too. I wonder what's going on here. Hang on a second. Yeah, the law and crime is freezing as well. And now they've moved to a picture of like the hallway. Yeah, and they don't have sound. Oh, I thought it was me. Law and crime is freezing as well, according to the chat there. So I do not know what's going on. So now we're just seeing the ceiling. Sub Rosa says, lower the resolution of the video so the internet has less work to do. I'll try again then. Yeah, I'm not seeing where I can do that. Okay, I'm going to try something else. Let's see. I hope I don't wreck it. Let's see. Okay. So that. And law and crime is black now. This isn't me, guys. This is law and crime has just gone off. I don't understand what's happening. They're having a problem too. See? Dippy, I did change to a lower quality to see if that helps. Okay, while we're sitting here waiting again. I wish I was a comedian or something so I could entertain you while we sit here and look at this black screen.
Case number 20.
William J. from the state. Judge, I'm James Owens. I represent Sarah Boone. From counsel, Lee.
Thank you, Mr. Henderson. Thank you, Mr. Owen. Any other appearances on behalf of Mr. Beck? Good afternoon, sir.
Kevin Beck on behalf. Good afternoon, Your Honor. I'm Kevin Beck on behalf of Sarah Boone as well.
Thank you. I'm going to moot Messrs. Beck and Henderson for the moment. We seem to be getting some feedback. If they need to speak, we can address that if and when that's necessary. We're here this afternoon on a litany of hearings. The court did receive the state's response to the motion to return property which just filed yesterday, and the state's amended notice or amended motion to strike the amended notice of battered spouse defense. The court was reviewing the authorities cited therein, which is why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right, any housekeeping matters from your side of the ledger, Mr. Owens?
Judge, I appreciate being here, and I just wanted to introduce my two assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all. Anything else, sir?
No.
Okay. To the extent we may be hearing from Ms. Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion to, the defendant's motion for statement of particulars. That was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars, and in my motion, I quoted the language in the information that she was charged with, and the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04 paragraph 2 by an act eminently dangerous to another and evincing a depraved mind regardless of human life did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know any time there is a weapon used, it's usually shot with a firearm that was used, that type of language, that is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. One, the victim is dead. Two, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres. This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is.
I'm going to interrupt. Yes, it's true they need to spell out how he passed away, how this killing was done. But, I mean, he was locked in a suitcase, right? And there's the but for argument. But for being locked in a suitcase, he wouldn't have passed away. And the singular purpose here was revenge.
In the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3 is of.
You know what that would be? That would be her videotaping him begging to get out of that suitcase. And she can't claim that she doesn't know that being stuffed into a suitcase is not dangerous because CPS talked to her about that. She was warned about that when she put her son in a suitcase for fun.
Such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Before he responds, I mean, this looks like they're just throwing everything against the wall and seeing what will stick. What he just said goes against battered spouse. So which is it? Are they claiming they don't know how he passed away? They don't know what happened? Or are they claiming she had to do what she did because she was a battered spouse and was in fear for her life? Which is it?
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, P-A-J-O-N, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida, 1st DCA 2020.
Can I have the second citation again? 305 Southern Second.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced, and they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case, and the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is...
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there.
But that's not actually true. because part of that language is whether or not the circumstance is extraordinary.
There, where it happened is there, the underlying charge is there.
I understand,
missing?
and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law, based on the unique set of facts, that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts, that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did that constitute. Is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary.
Okay.
Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All of this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
Moving now.
That's a really good point that the judge just made. A whole lot of other attorneys have seen this, and nobody has brought up this issue. And not only that, they felt that they had enough information that they could respond.
Now to, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were.
Oh my gosh. Do you remember after her interrogation, she said, well, you tricked me. No, they didn't trick her. They brought her down to talk to her and they found the video. And what are they going to do? Let her go and have her come back? And it's okay to get somebody down to the station on a pretext. And as the detective said to Sarah during the interview, was, look, did you want us to come to your house and arrest you in front of your son? And this business about Miranda, well, she was read her rights. Not only was she read her rights in the car before they even got to the station, she was read her rights at the station. She was read her rights on camera. And while they did that, while they read her rights, they got her to say, you remember we read your rights earlier? We read your rights before? And she said, yes, that's right. So she was. And this business about it being coerced, do you remember Sarah's letter about, oh, the one detective was wearing his gun? As if they somehow coerced her? No. Anything that doesn't end up going her way is somehow somebody else's fault. There was no coercion here. Not at all.
I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on...
Oh my gosh. She was in a room where she couldn't leave. Yeah, that's how it goes.
Improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, The state attorney has tremendous power. I've made this request, what was it, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two detectives, the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court.
Basically, you can't send the prosecution running around doing your work for you because you're in a hurry because your client didn't do anything before. And you can't send the state out to go on a fishing expedition on your behalf.
Today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does.
Do you remember when we talked about this before? And I cautioned everybody listening, there is a difference between policy and law. Doesn't matter if they violated the policy as long as the law wasn't violated. And that is exactly what he is arguing now.
Does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing? What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases, said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct, and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here, because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements, because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, or I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And again, she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. but I've got to read you these Miranda rights. And she said something, and Sarah said protocol, because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda, judge, she made a mistake on it. I don't know if it's an anonymous mistake, but in her probable cause statement, she said, I read the...
Unless there is a specific American case law, it doesn't matter. What he's saying doesn't really matter in the end. It doesn't matter what Sarah thought that they were going to talk about, even if the detective led her to believe they were going to talk about X and they ended up talking about Y. Sarah's read her rights, and that includes the right to remain silent, the right to an attorney, that sort of thing. So at any point, Sarah could have said, yeah, I don't want to talk about this anymore. I'm not going to say anything anymore. She could have done that at any point, and she did not. She was focused on convincing them that George was terrible and she was wonderful.
Rights verbatim. The constitutional Miranda rights I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
Yes,
excuse me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think
that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for...
I think this lawyer is not stupid, and I think he knows the difference between law and policy. It doesn't matter. And it seems like he is missing the point on purpose.
Reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and...
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your...
Ooh, so now this lawyer knows what the judge is going to ask and can tailor his arguments accordingly. I would find it wild if he is going to try to claim that Sarah did not understand what her rights were as they were read to her. It sounds like that's what he's implying.
Your first question is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective. They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in, if those statements are admissible, and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your.
Could you imagine if police policy was the determining factor as to what was admissible or what jury instructions could be? No police department would make any policy at all. It's bananas. So I think what the prosecution is saying here is right on.
Your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken in, is what it is. I think State versus Wright is the guiding light for the court here. 803 Southern 2nd 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing, and we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
I don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll have to ask Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
give you my copy?
And Mr. J, have you seen that, sir?
The state doesn't really have a dog in the fight with the expert opinion.
Understood, thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
it was filed this afternoon,
Okay.
this morning.
Okay. All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's nunc-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her, and she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last...
When was that, you're asking nunc-pro-tunc to win on that? Also to the August 30th date of your notice of appearance?
If possible, yes. That's when I officially got on the case.
Okay. Now, as to the third motion for cost, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I had mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Berkland, and it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says before I make a decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Is it Central?
Is that in person or is that virtual?
I believe
Okay.
the state's flying in, and I'm going to be their judge. That's the county over from me, Santa Rosa County, so about an hour drive for me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good.
I think they wanted the clinical psychologist to say she's not malingering, but I'm not 100% sure.
Excuse me. No, Dr. Michael Brandon. It had to be filed. Michael Brandon.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
Sounds like they're not putting
It was
dates
filed
on your
just prior to
paper.
filing these amended ones.
Well,
It had to be filed prior to my motions for appointment of these experts.
Give me a second. Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted, non-protunct, to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken, and I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response.
It makes sense that he would deny it, but it looks like the defense realized that that's what was going to happen, and they've pretty much abandoned that anyway. I wonder if Sarah was really pushing the lawyer to get that phone. She really wants that.
And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm going to do my best. We've got about 18 days.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance, and Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I had filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing, I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records.
You know, they have to get corroboration, they're saying. But everything they do, you know, the state has to come up with something to counter it. So the state has a whole pile of extra work to do as well.
Her phone and the information on her phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD. And I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD. I'll wait. I was going to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot quite ahead of it, that she would try to get to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But it's just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to cooperate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed.
Mr. Owens, you're having so much difficulty and you are so overburdened because your client has been an idiot for the last 4 years. It's not the judge's fault.
I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone. But battery on Sarah Boone. They, if anybody.
Do you see how this is going to get twisted around? Can you just see that? Wow. I'm not saying that what he did was okay, but once again, you know, a whole lot gets omitted and it gets spun.
Was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape, please look at my phone, please look at the videotape, please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason...
Look, it's not like the state has failed to disclose any of this. All of this was available. I mean, we all knew about it, right? And there was a phone extraction. That was given to the defense. So this is not like they've been hiding all this information. And inmates know that your jail communications are not private. And so maybe there is something in those communications from her inmate tablet that is pertinent or that may become pertinent. And the state is doing its job by saying, well, we're going to send you this stuff. So if they didn't send it, they'd be in trouble. And if they do send it, he's going to argue about it.
The reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from a battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If, in fact, he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it.
You know, the state saying, yeah, we're aware you're going to make this application, they make this motion, we're aware you're going to try and use this defense. Yeah, we're ready for it if you end up using this defense. That is not the same as saying we agree with you using this defense. It's not the same thing.
I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone. And the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women's syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
By the way, the fact that they've listed Brian Boone is really interesting. Once you get into court and you're arguing back and forth, it's not like you can cherry pick your arguments. If Brian is to get up there and tell the whole truth, and that's the thing about the whole truth, it's not always black and white. It's not always for one side or the other. The whole truth from Brian would be, yeah, George hit her. And also, yeah, George lashed back at her. And yeah, before she met George, she got violent when she was drinking. And before she met George, she physically attacked me. So if they want to put them up there, I mean, it's all going to come in. And it's all pertinent then if she is alleging battered spouse. Because the question is then going to become, well, who is violent really? And whether or not she has this syndrome, and even if she did have battered spouse syndrome, that doesn't mean that at the time of the crime, she was acting as a result of that. There's going to have to be a lot more fleshed out for that to work. I don't think it's going to fly. We'll see.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense, it is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome, and here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify.
Zing! Yes, she would need to testify, and that will be a train wreck for the defense. Also, in order to claim self-defense, I mean, even if they got those interrogation videos cut out, she's running around telling everybody else. She told everybody at the complex it was an accident, not intentional. The body cam video from the first responding officer, not intentional, not intentional. Well, then where's the self-defense? The only way to claim that is to completely come out with a whole new story that none of us have heard. Now, you all know that I believe the whole hide and seek he got in the suitcase is absolute rubbish. She made it up. I believe that. I believe something did happen, and I believe there is a reason for the sudden silence in the middle of a big knockdown, drag out fight before there was a huge crashing down the stairs. I don't believe that suitcase was being kept downstairs awaiting, a donation. All of that is nonsense. He was upstairs. She incapacitated him. But she's going to have to explain that then in order to use this defense. So, the Sarah Boone herself, with all her game playing, has put herself in a very difficult position.
And then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice, and I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is
Is the defense arguing the prosecution's side right here?
It's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located.
So now I
Battered
don't know what's
spouse
going on
syndrome
here.
as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused, and that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase? Was that the overt act that caused the death?
But all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did.
Right. So the defense kind of talks out of both sides of his mouth. At the beginning of all this, he's claiming we don't know, and now he wants to use battered spouse, in which case he needs to know.
How is that applicable to the case at bar?
I assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase, against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said, on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah.
And you know what? That's right. The state doesn't know what happened the 2 minutes prior to the making of that video. They don't really know, truly, what happened 15 minutes prior to that. They don't know what Sarah Boone did. Why is that? Because she's lying her face off, and she has from the beginning. Because she did something. And when she was interviewed, she was hiding time both at night and in the morning. She was hiding time like crazy. So she was doing something during at least 2 periods of time that she has kept close to the vest, and she has told nobody. So no, they don't know.
Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay.
Not accident as they, meaning the prosecution, wants to allege. No. The prosecution was not alleging accident. It was Sarah Boone who has been saying accident all along.
Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but I have some concerns because I'm getting reverb from you.
I am trying to talk to you now. Are you able to hear me better?
I am, but it's my that we're hearing back again through your microphone.
Turn that volume down.
This may work.
He needs headphones or something.
Mr. Henderson, we'll give this a shot, sir. You can go ahead.
Yes, sir. Can you hear me now?
I can, sir.
Is that better?
Yes, sir, it is.
Yes. Yes, Judge. I'd like to respond. And first, where I want to start is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force. Those are defenses that do not require notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is that it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence, is what the cases say, to get the instruction. There's no notice requirement in self-defense at all. Now,
But there is notice required to use battered spouse syndrome defense.
battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger, and that because of this syndrome, they would perceive an imminent danger different than someone else. Because what the self.
Okay, I'm going to interrupt this and make some commentary that I was going to save till the end, but I'm finding this very difficult to listen to. We'll listen to the whole thing, but I just want to interrupt that noise for a minute. He's talking about how people with battered spouse syndrome, it's kind of like PTSD, right? They would perceive threat or danger differently from other people. And I think everybody can understand that when you see maybe somebody who has been hit a lot will react like that, like put their arm up in defense even when nothing is happening. People who have been through a lot of trauma will be hyper vigilant. They will perceive things differently. They will perceive things as a threat that wouldn't be perceived that way to somebody else who hasn't suffered that. But it has to be relevant to the facts at issue. It has to be relevant to the circumstances of the crime. And in this instance, Sarah claimed that she didn't zip it up the suitcase all the way, that his fingers were sticking out, which is baloney. She's lying, but that's what she claimed. And that she believed, she stated several times, she believed he could get out on his own. So if there was imminent threat and she was fearful that if he got out, oh boy, she'd be in trouble, then it doesn't make sense that she wouldn't zip it up all the way. Also, if he is fine in that suitcase and able to get out on his own, then what person who is fearful for their life, who believes they're facing an imminent threat, what person can then just go to sleep, right? If you're fearing for your life and you got the guy down or restrained, do you not run out the door? So I don't think any of this is going to fly. This kind of feels like a waste of time, but it's useful argument, I guess.
Defense instruction required is that the jury place themselves in the position of the defendant in those circumstances at that point. That was to help explain those circumstances. So the first instruction that you have to get before you can even start talking about that spouse is this. You have to get the self-defense instruction. So, and that would be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of self-defense, then the court can get that instruction. If they want to present the testimony, can get that instruction as to self-defense. Where that is not comes in, as it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into that trial. And this is how it should. There can be the testimony of his will. There can be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There can be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not before that point, can the expert come in and testify. So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time. Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was the interviews, this was reviewing other type of data and other types of things and preparing their expert opinion. So after that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. jury to decide. And what it does, and it doesn't say that battered spouse is a defense. What it will talk about in the jury instruction is this is something in the back of the under these circumstances, if you find it credible, that you can consider. And that's what it does. So we are at the beginning here when we start talking about motions to strike, because if I think the case was Wagner, there wasn't any testimony there. Wagner's testimony was accident, and that had, and I really put no one reviewed the ruling of that. That was the testimony. In this case, we do not have testimony. What we have is a say in this case saying the discovery in this case don't get it. But that's not trial. These rulings have to be made better on the testimony of critical report, either testimony itself, critical evidence.
Mr. Henderson, we're having a difficult time understanding you, sir.
I'm sorry, Judge. Is that better?
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Okay. Judge, my name's talking to you, but it might be to hear me better. Can you hear me better now?
Madam Court Reporter. We will do our best, sir. Keep going.
Yeah. So, to break it in for landing, Judge, is simply this. Until the court hears the evidence that the permitted at trial, the court cannot make certain decisions. The court can't make a decision if justify the use of non-deadly or justify the use of deadly force is appropriate to give, and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there isn't any testimony to prove the relevancy or to show the relevancy of the expert's testimony, then that expert can't come up and talk about battered spouse. Now, if you don't get the expert to talk about battered spouse and render an expert opinion, battered spouse is out the window. So then you're just on self-defense at that time. But that argument and that decision can only be made after the evidence is put in that trial. And that's all I have, Judge. Thank you.
Mr. J, any response?
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's in Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page, that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense in particular, was, did this violence cause her to suffer from battered spouse syndrome, and what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog, and then like everybody else, we were playing hide and seek, and he got into the suitcase, and I accidentally went to sleep.
He's bringing up good points. And if they really wanted to get into it, the prosecution or people on social media could argue that this battered spouse syndrome and the trauma is actually reversed, because it was Sarah who had control over the money. It was Sarah who had control over the cell phone. In the end, he ended up not having his own phone. He had to use hers, which was not only password protected, but it operated by facial recognition. So he's not using it without her being there. She stopped him from talking to his brother his last night on Earth. She was the one who controlled things. She went to his parents' house and picked him up in spite of a no contact order. So you could reverse it. And the prosecution's right. He never threatened her, said you can't leave at any time, even during the bad parts of the relationship when they were going through something. She was able to leave. He didn't prevent that. So, yeah, they're going to have a hard time with this.
And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
He's as bad as
I'm
me.
sorry. Can you
Almost.
hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates, and I think that's a typo on paragraph 3. I said August 17, that should be September 17. On paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry, I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move, so we need more time, is my point. We're doing.
Does the state not have that information? Would they not need to have that information because they're going to have to subpoena him for trial? Or they should have subpoenaed him already.
Everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my...
Did you all catch that? Sarah says the information extracted from her phone is incomplete. I wonder what's on there that she thinks ought to be on there and isn't. Or did she look at all the extraction and not see what it was she was looking for? Or did she think something was on there and maybe she deleted it and forgot? Very interesting.
Motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And
have to testify through a narrative. And I mean, maybe I'm reading too much between the lines, but that sounds to me like, look, we all know she's lying, so the defense isn't going to get up and ask her questions when he knows it's going to elicit a lie. So she'll have to just tell a narrative. The other thing I appreciate him doing here is to repeat again that this is not Mr. Owen's trial. This is the defendant's trial. And the defendant has known about all of this for over 4 years. The fact that Owens came on late doesn't mean that everything, all the rules should be bent and every accommodation be given and rules be broken and the prosecution thus being put at a disadvantage because they can be, suddenly ambushed in the middle of trial by some new information. Because Sarah Boone failed to properly deal with her case for all this time.
there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
And she's been complaining, let's get the show on the road. It's overdue. My trial, it's overdue. Yet she's the one who ends up causing it to be delayed. And now they want special treatment because she didn't do what she's supposed to do for all this time.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
Just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning. Get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday, and we'll start whittling it down. And I can turn over, when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state, and I'll turn it over to you, and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate, I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m., I got 50 people teed up for 1:30, and that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies, and we don't have them. Now, if we're able to get a jury in one day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask, up until the time we pick the jury, that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further position, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. We were not contesting it beyond objecting. We do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owen's involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert that's being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name. I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit. We don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense. But that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, in excess of the rates for the circuit, those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, you know, that the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc-pro-tunc because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September.
Yeah, is that not what I just said? I'm sorry if I said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
This relates to the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge Z.
Billy Lane has already been authorized for $10,000. So are they going to be asking for more?
The other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes. So do I need to file something?
I have, get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Three key members of Owens, Eric Click, E-R-I-E-C-L-I-C-K, had provided the total amount of clothing that they had that would fit Ms. Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign, was to have the shock based on her lower leg. I would ask that you email Ms. Click, you find her information on the webpage, and ask her if the public defender's would provide clothing they were going to, while Ms. Boone was representing herself, and that would still be accepted.
Judge, I anticipate two more pre-trial hearings. One is the case management conference, and two, if I file a motion to suppress the second day of interrogation, we probably have a second day. If she wears street clothes, those 2 hearings.
If you could get to her, so that's something you have to work with corrections, but they're going to let you do that.
And when it comes time to trial, we would like, she would like, for us to make up for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that? Or? Okay.
What? They have a hairdresser or something in jail. I know that. But she wants, like, okay, they didn't say somebody to fix her makeup, but she wants makeup and she wants hairdressing services beyond what she is provided. I mean, really? Does she want a director's chair too?
I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
Okay, I think that's it. Wow. Well, they got a lot done. There were a couple of things I jotted down because I kept glancing up at the chat and saw a couple of things that I wanted to answer. Somebody was asking about battered spouse defense and whether or not that is like a law or something. And I think Mr. Henderson's submissions on that issue pretty much covered that. The whole thing with this defense is it is a self-defense defense. And battered spouse is not, somebody even in the comments said, why wasn't she charged with this? It's not a charge. It's kind of like a PTSD. Somebody asked a question about the suitcase and why it was that he passed away. How can you asphyxiate inside of a suitcase that is soft? It permeable. So how can that happen? And it's not just whether or not there's airflow. There's something called positional asphyxia. And, you know, every time I see something on the news where somebody is detained by police and placed on their stomach, especially if they're cuffed in a way, they call it hogtied. When they're placed on their stomach, that's cause for great concern because people pass away because their chest is compressed and their diaphragm is compressed and they can't breathe properly and they asphyxiate even though there is plenty of air. And they did studies on this because so many so many individuals who were taken into custody suffered this outcome, and they wanted to know why. And so now up here, we no longer do that unless it can't be avoided. So that is probably what happened. And somebody asked, has the judge seen all the evidence? The judge would see everything that's filed, but the judge doesn't sit there. Like, the judge hasn't seen her interrogation videos or anything like that. We're going to have to watch for this motion to suppress her interrogations. I don't think that's going to fly. But here's what the prosecution is worried about, is if they can suppress her claiming that it was not intentional, her claiming that, oh no, nobody laid a hand on anybody and everything was good. We were good for a long time. We were fun. We were having fun. It was a good day. All of that. If they can get rid of all that and replace it with, oh my gosh, I was fearful, and introduce Mr. Torres's history, then they can try and spin that for the jury. And I think that is what the prosecution's worried about. So let me look at the chat here. Oh, you're talking about cats in the chat. Yeah, okay. Christina Garcia, she had knocked him out and stuffed him in the suitcase and pushed it down the stairs. That's exactly what I think happened. And by the way, I'm going to look into what the heck happened with the technology today. I don't want that to happen during the trial. So I don't know if I can fix that, but I'm going to try. I'm going to make some phone calls to some people who know more than I do. So we have multiple conversations going on in chat. So I don't know what's happening there. Okay. So I think I'm not seeing any specific questions. I answered the ones I caught. So I think I'm probably going to end the chat. Christina says hide and seek is ridiculous. Yes. Oh, AKA the cat lady. How are they getting Dr. Brennan when he was on freaking court TV at the same time as the last hearing, watching the hearing, and Brennan says he didn't think Sarah fit battered spouse? That is almost comical. I think an easy out for him, if he agrees to take this on, is that, well, it's one thing to opine based on whatever's available to the public, and it's quite another thing to do a proper assessment, a proper interview and assessment. Okay, so I think I'm going to end the stream now because I'm not seeing a lot of questions here. Thank you for joining me and chatting with each other and chatting with me. I will see you next time. Trust your guts. That sounds terrible. Trust your gut. I'll see you in the comments.